I found my daughter sitting on the front steps of my house with a laundry basket and a duffel bag and my granddaughter asleep across her lap. It was 6:30 in the morning. I had not had my coffee yet. My daughter looked up at me and her eyes with a kind of red that does not come from crying for an hour. That comes from not sleeping at all. She said, "He changed the alarm code, Mom, and he had my name taken off the lease." I looked at her. I looked at little Maeve, 4 years old, mouth open, one shoe missing. I said, "Let's get her inside first." That was the moment I knew how the next several weeks were going to go. Not because I was panicking, because I wasn't. I have been a licensed CPA for 31 years. I have handled estate disputes, business divorces, forensic audits. I know what money does to people when they think no one is watching. I know what it looks like when someone has been planning something for a long time and is only now letting you see it. My daughter's husband had been planning this. The laundry basket told me that. You don't pack a laundry basket in anger. You pack it when you've thought about what you need and decided you're only going to have one trip. My daughter's name is Laurel. She married Noel 6 years ago. I want to be fair about this. I did not dislike him in the beginning. He was attentive, he had steady work as a project manager for a mid-sized construction firm, and he made my daughter laugh in a way I had not seen since she was in her 20s. I had concerns. I am a mother. I always have concerns, but I did not interfere. That is not the kind of mother I am. What I did not know at the time of their wedding, what Laurel did not know, was that Noel's mother, I will call her his mother because that is what she was, that is her whole role in this story, had given them $35,000 toward the down payment on their house. I found this out that morning on my front steps. Laurel told me while I made coffee and Maeve slept on the couch with my old throw blanket over her. "She gave you $35,000, I said. "As a wedding gift," Laurel said. That's what she called it. A wedding gift. And was there paperwork? Laurel looked at me the way my clients look at me when they realize they should have called me sooner. "I don't think so," she said. "I don't remember signing anything." I turned back to the coffee maker and did not say what I was thinking. There was time for that later. What I said was, "Tell me everything, from the beginning. Take your time." So she did. She and Noel had been struggling since before Maeve started school. She described it the way people describe a slow leak. Nothing catastrophic, nothing you could point to on a single Tuesday and say, that is when it broke. It was the accumulation. He stopped telling her things. Not lying, exactly. Just not telling. The finances, the decisions at work, the conversations he had with his mother on the phone that he always took in the other room. Laurel said she had started to feel like a tenant in her own life. Like someone who lived there but did not belong to the place. She had asked him 3 months ago if they could try counseling. He said yes. They went twice. Then he stopped making appointments. And when she asked about it, he said the therapist wasn't a good fit, and they'd find someone else, and they never did. What she did not know, what she found out only 2 weeks before she arrived on my steps, was that Noel had been talking to a real estate attorney. Not about buying something new, about the existing house, about the title. Their home was in both their names. That is what Laurel had believed. That is what she had been told at closing. What had actually happened, and I want to be precise here because precision matters, is that the mortgage was in both names, but the deed had been structured differently. Noel's mother had insisted, as a condition of her $35,000, that the property be titled with a specific arrangement that I will explain simply. In a dispute, her son's interest would be protected before Laurel's. It was not illegal at the time of signing. It was not disclosed clearly, and Laurel, who was 29 years old and in love and not a CPA, had signed with the attorney appointed and had not asked the right questions because no one told her there were right questions to ask. I finished my coffee. I got out a legal pad. I said, "I need you to find every document from the closing. Everything, whatever you have." She had them in the duffel bag. That surprised me. I did not say so. I spent that afternoon reading. By 4 o'clock, I understood the situation completely. By 5 o'clock, I was angry. Not loudly. I do not do things loudly. But I sat in my office with those documents and I was very, very angry because what had been done to my daughter was not an accident. It required planning. It required a real estate attorney who understood exactly what language to use. It required a mother-in-law who had decided 6 years before that her son's marriage was a temporary arrangement and had structured her gift accordingly. And it required my daughter to be young enough and trusting enough and in love enough not to notice. I thought about that for a while. Then I picked up the phone. I have a colleague named Ruth Ann. Not a lawyer, but she has been in real estate finance longer than I have been doing taxes, and she knows people. I told her what I had. She was quiet for a moment and then she said, That arrangement with the deed is aggressive, but it's not bulletproof. And if he changed the alarm code and had her name administratively removed from building access, that's a different conversation. What kind of conversation? I said. The kind that involves her being a joint tenant on a mortgage and having her access removed without a court order, she said. That is not legal. I said, I know. She gave me the name of a family law attorney she trusted. I wrote it down. That evening, I sat with Laurel at my kitchen table while Maeve ate cereal for dinner, because that was what she wanted and that was not a battle worth having tonight. I told Laurel what I had found. I told her calmly. I watched her face go through about 6 different things and then settle into something I had not seen on her in years. It was not quite anger. It was closer to clarity. She said, she planned this. His mother planned this before we even got married. The structure of the deed suggests it was a condition, I said. I can't tell you her intentions. I can tell you what the documents show. Laurel was quiet for a moment. Maeve pushed Cheerios around her bowl. Then Laurel said, What do? I said. You don't do anything tonight. Tonight you sleep. Tomorrow I make some calls. She started to say something and I held up my hand. I know you're scared, I said. I know, but panic will cost you more than the situation will. You are not in as weak a position as he wants you to think you are. She nodded. She didn't fully believe me yet. That was all right. She would. I called the attorney Ruth Ann recommended the next morning. Her name is Frances. I am not going to give her last name here, but she has been practicing family law in this state for over 20 years, and she has the kind of direct manner I appreciate enormously. I have no patience for professionals who soften everything so much that you leave the office not knowing what was said. Frances was not like that. I walked her through what I had. The deed structure. The $35,000. The mortgage in both names. The removed access. She asked questions. Good questions. The kind that told me she was already thinking several steps ahead. When I finished, she said, the access removal is the most immediate issue. That is actionable. A joint mortgage holder cannot be locked out of a property without a court-ordered separation agreement. There isn't one here, correct? Correct, I said. Then, he exposed himself significantly, she said. The deed structure is a slower conversation, but it is a conversation, particularly if the $35,000 was characterized as a gift with no written conditions at the time of signing. If his mother wants to argue now that it came with strings, she is going to have a difficult time explaining why those strings were never disclosed. There's a child, I said. That changes the calculus for everyone, she said. Frances filed an emergency motion that week. I want to explain what that means in practical terms, because I think a lot of people believe legal processes are faster or more dramatic than they are. An emergency motion is not a SWAT team. It is paperwork, filed urgently, asking a judge to look at something quickly, because waiting would cause harm. In this case, the harm was that my daughter and her 4-year-old child had been removed from their home by means that were not legally permitted. The court scheduled a hearing within 10 days. In those 10 days, several things happened. Noel called Laurel twice. The first call was what I would describe as performative. He was very calm, very reasonable. Said this was all a misunderstanding, said she had left voluntarily, said he had changed the alarm code for security reasons after she left. Laurel recorded the call. That was my instruction before he called. If he calls, record it, say as little as possible, and call me immediately after. She followed those instructions. The second call was less performative. He said some things I'm not going to repeat here because they do not add to the story, and I do not think they deserve to be repeated. What I will say is that Laurel recorded that call too, and what he said in that call became relevant later. His mother also called. She called my number, which surprised me. I did not know she had it. She said she thought we could resolve this between families, and that lawyers were going to make everything worse. She said the $35,000 had been a gift given in good faith, and she hoped it wasn't going to be used against her son. I said I appreciated her calling. I said I would pass along her thoughts. I said goodbye and hung up and called Frances. Frances said, She called you directly? Yes, I said. There was a pause. Interesting, she said. That suggests she is more worried about the deed structure than she wants to appear. That was my read as well, I said. The hearing was on a Thursday. I drove Laurel there. Maeve stayed with a neighbor I trust. Laurel wore a blue blazer she borrowed from me, and I noticed she had fixed her hair the way she used to wear it before Maeve was born, when she was working downtown and had a routine and her own sense of herself. It made me glad and sad at the same time in the way that most things involving your children do. The hearing itself was not long. Frances argued that the removal of access from a joint mortgage holder without a court order was improper. Noel's attorney, and he had gotten an attorney quickly, which told me something, argued that Laurel had left voluntarily. Francis produced the recording of the first phone call in which Noel himself described the access removal as something he had done, not something that had happened, something he had done. The judge ordered that Laurel's access be restored within 48 hours, pending a full hearing on the separation. When we walked out of that building, Laurel stopped on the steps and stood very still for a moment. She wasn't crying. She was doing what people do when something they were afraid might not be real turns out to be real. I put my hand on her arm and said, "That is the first step, not the last one." She said, "I know. There's still a lot to figure out," I said. "I know that too," she said. We went and picked up Maeve. The fuller process took several months. I am not going to walk through every step because that would take longer than this, and most of it was waiting and documents and phone calls. What I will tell you is the important parts. The $35,000 was ultimately treated as a marital gift, with no enforceable conditions, because when Francis requested documentation of any written agreement between Noel's mother and the couple at the time of closing, none existed. What existed was the deed structure, but without a signed agreement establishing the conditions of the gift. Arguing that structure as an enforceable contract became significantly more difficult. Noel's mother had assumed, I think, that the deed language would speak for itself. It did not speak loudly enough when there was no signed document to back it up. Maeve's custody arrangement was worked out separately. I am going to say only this about that. Laurel is a good mother, Noel is, in his way, a present father, and what was agreed to is workable. Maeve goes back and forth, and she has the plastic horses she loves at both houses now. That is what matters. The house was ultimately sold as part of the settlement. Laurel got her share. It was not everything she would have had in a more straightforward situation, but it was not nothing. It was enough for a deposit on an apartment in a neighborhood she likes, with a room for Maeve that she painted herself, a pale green, the color Maeve picked. What I want to say now is something I have thought about a lot in the time since this happened. I am not telling this story to make Noel or his mother into villains. I think they made choices that they believed were in their interest. I think his mother believed she was protecting her son. I think Noel believed that the way he had structured things left him in a stronger position. They were not wrong that the structure was designed to protect him. What they did not account for was Laurel having someone in her corner who knew what the structure actually meant, and what it didn't mean, and what questions to ask, and who to call. That is the thing that keeps me up at night a little. Not what happened to my daughter. She is all right. She is more than all right, actually. She is better than you was, which is not a thing I could have said with confidence the morning I found her on my steps. What keeps me up is thinking about the women who don't have someone who knows those questions. Who sign where the attorney points because they are in love and the room is full of people waiting and no one tells them there are right questions to ask. Who spend years in a situation that has been arranged around them without ever knowing it, and who, when it ends, don't know what they signed or what rights they have or who to call. I have given Francis's information to 4 people since this happened. 2 of them have called her. I think about the other 2. If you are watching this and something in it sounded familiar, the feeling of being managed rather than partnered, the sense that decisions are being made around you rather than with you, papers signed in rooms where you felt uncertain but didn't want to slow things down. I want you to know that uncertainty was information. Your instinct was not wrong. It was just ahead of what you knew how to do with it. You do not have to be a CPA. You do not have to know real estate law. You have to know that you are allowed to ask questions and insist on answers and bring someone with you who will ask the questions you don't know yet. That is all I wanted to say. There is a link in the description to a document I put together on questions to ask before signing any property-related paperwork. What to look for on a deed, what gift documentation should include, what it means when an attorney is representing the transaction rather than representing you. It is not legal advice. It is a starting point. The difference matters, and I want to be honest about what I am and what I'm not. If there's something specific you'd like me to talk through, what joint tenancy actually means, how to find someone to review documents before you sign, what to do if you're already in a situation and you're not sure what you signed, leave it in the comments. I read them. I answer the ones I can. You do not have to figure this out alone. That is the whole point. I have been doing this long enough to know that people rarely plan one thing. When you find one piece of carefully arranged paperwork, there is almost always another. Noel's mother did not put $35,000 into a deed structure because she was generous. She did it because she was afraid that her son had chosen someone she couldn't control, and she wanted a mechanism in place for the day that fear turned out to be correct. That is not love with conditions. That is a transaction disguised as love, and there is a difference, and the difference matters enormously when you are sitting across from a family law attorney trying to figure out what you actually own. What I keep coming back to is this. Laurel did nothing wrong the morning she signed those papers. She was 29, she was happy, and the room was full of people moving things forward efficiently, and no one said, "Wait, do you understand what this section means?" That is the trap. It does not announce itself. It just looks like a closing. The choices we make when we are not paying attention, or when we don't know we should be paying attention, don't disappear. They sit inside documents and filing cabinets and they wait. Noel's mother understood that. She was patient. What she didn't account for was that patience works both ways. I have been patient for 31 years. I know how to read the documents. I know what questions expose a plan that was never meant to be examined. There is something I want to say about Laurel, because I think it gets lost in stories like this. She was not passive. She showed up on my steps at 6:30 in the morning with every closing document she owned already in that duffel bag. She did not know exactly what she had, but some part of her knew she needed it. That is not nothing. That is a woman who, even in the worst night of her life, was thinking clearly enough to take what she might need later. I am proud of that. I told her so. The apartment she lives in now is not the house she thought she would have. That is a real loss, and I am not going to dress it up. But the room Maeve chose, that pale green, the color she pointed to in a paint swatch like it was exactly what she'd been looking for, that room is hers in a way that the other house never fully was. There is something in that worth noticing. I do not think people who do harmful things always understand that they are doing harm. I think Noel's mother believed she was protecting something. I think Noel believed the structure he'd built was just practical. What they both failed to account for is that the people on the other side of those decisions are not variables. They are people with their own resources, their own knowledge, their own mothers who spent 3 decades learning exactly how this works. You do not need to know everything. You need to know enough to ask the next question. And you need to know that when something feels off, when you are in a room and moving fast, and your instinct says, slow down, that instinct is worth more than the efficiency of the moment. It almost always is.